name is Alec Osland, and I'm an attorney at the Yanowitz Law Firm, where we've been helping families with wills, trusts, and probate for over 30 years. Today, we're going to talk about how to make sure that you use the Minnesota state tax exemption. So, what is the Minnesota state tax exemption? Minnesota has an estate tax on estates that are larger than $3 million. That means for married couples, each spouse has a $3 million exemption. It is very important that in order to utilize each spouse's $3 million exemption, which equals, up to $6 million, that we have the proper type of estate plan put together. What I mean by that is that an estate plan must have a type of credit shelter trust that is built into the estate planning documents that is set up when the first spouse passes away, and we want the assets to fund into this credit shelter trust following the death of the first spouse so we can utilize their exemption. It is very important and actually required that to have this type of plan put together, both spouses need to be alive when this plan is enacted. So very important that you meet with an estate planning attorney while both spouses are alive to set things up correctly. So a lot of people have what we consider like an I love you wills or an I love you type of estate plan. What that means is essentially upon the death of the first spouse, they leave everything to the surviving spouse. Their will or estate planning documents may say something along the lines of, when I pass away, I give everything outright to my surviving spouse, or all my property to my surviving spouse. So the issue with that type of plan is that the assets are going directly to the spouse and you're not funding this credit shelter trust. Now, depending on the type of plan, the spouse may have the opportunity to disclaim those assets and get them funded into the credit shelter trust. So it's not your documents just because they say that. They may not be wrong. It just depends what is also in the document as well later on with certain provisions if there is that credit shelter trust. With those I love you type of plans, we generally also see that spouses hold a lot of the assets jointly, or the spouse is named as the pay on death beneficiary for like a life insurance, brokerage accounts, and other assets like that. Again, that may not be wrong depending on what type of plan is put together, but it is very important that in the situations that we want to fund that credit shelter trust, that the spouse disclaims those assets so they don't actually go into their own individual name, and that those assets actually fund to the credit shelter trust. Again, very important that those assets, we have an instruction and a way to get them to fund in that credit shelter trust, because if the spouse just takes that asset as the surviving joint owner or takes that asset as the pay on death beneficiary, doesn't do anything with the essentially conveying that asset to the credit shelter trust, we are essentially throwing away that first spouse's exemption, and once we throw it away, we can't grab it back. So a lot of times with our credit shelter trust plans, and we have this a lot like with trust-based estate plans, what it looks like is we actually set up a lot of the accounts to go actually to the first spouses to die. We have it go to their trust. So we name their trust as the beneficiary on life insurance, brokerage accounts, some of the real estate, and other financial assets as well. What that allows to happen is when that first spouse passes away, those assets fall to this credit shelter trust, and the surviving spouse is actually the trustee of that credit shelter trust. Depending on the provisions of what the estate planning documents say, that's going to govern how that surviving spouse can use those assets that are in this credit shelter trust for the remainder of their life. So again, what that allows to happen is when the first spouse passes away, we have the assets go to this credit shelter trust that's established in their estate planning documents, and we can utilize that first spouse to pass away. We utilize their exemption because the assets that are in this credit shelter trust, they don't count to the second spouse to pass away because we're using them towards the first spouse's exemption. So when that second spouse passes away, they still have their $3 million exemption for the Minnesota estate tax. So the big takeaway here is we want to make sure that your estate plan is done correctly and that we have the appropriate language in your estate plan to fully fund that credit shelter trust upon the death of the first spouse. Again, why is this important? What does it mean? It is important because if it's not set up correctly, we are going to lose the potential to protect $3 million from Minnesota state tax for each spouse. So again, it's use it or lose it. If you don't use it, it's thrown in the garbage and you can't grab it back. All right. So There's quite a bit that goes into draft the specific provisions regarding estate plans with credit shelter trusts, which is why it's very important that you work with an attorney and a law firm who knows how to correctly draft these documents to make sure they can accomplish all of your goals and wishes. I'd like to thank you for joining me today. I hope you learned about how we can utilize each Minnesota estate tax exemption of that $3 million per spouse, and I hope to see you in the office. Thanks. Have a great day. Bye.